Now we'll discuss an important issue, that is playing of national anthem at cinema halls. Now first of all, we look into what are the existing laws in regard to national anthem. So the first is that you have the fundamental duties, that is Article 51A itself mentioning about the national anthem, and it states that it shall be the duty of every citizen of India to abide by the Constitution and respect its ideals, institutions, the national flag and the national anthem. So that is the Article 51A. And then you have another act that was passed in 1971 which states, which is called as the Prevention of Insults to National Honor Act, and it states that whoever intentionally prevents the singing of the Janagana Mana or causes disturbances to any assembly that is engaged in such singing shall be punished with imprisonment for a term which may extend to 3 years or with fine or both. So that is in regard to the existing laws. We have existing judgments also in regard to national anthem, and the famous is the Bijo Emmanuel versus State of Kerala case. Now in this case, a particular school expelled 3 students for not singing national anthem even though they stood up in respect of the national anthem. So this was taken, and the court ruled that there is no provision of the law which obliges anyone to sing the national anthem, nor is it disrespectful to the national anthem if a person who stands up respectfully when the national anthem is sung does not join in the singing. So this was given by the court in regard to the Bijo Emmanuel versus State of Kerala. Now in 2016 we have a case that is called as Shyam Narayan Chouksey versus Union of India case, and in this the Supreme Court gave some important rulings. Now what are the court rulings? The first thing is that the Supreme Court made it mandatory for cinemas to play the national anthem before every screening, and for everyone in the audience to stand up and show their respect. So that's the first thing. Second thing is that it made it compulsory for the national flag to be displayed on the screen and the doors of the cinema halls to be closed while the national anthem is being played, and it also banned the commercial exploitation of the national anthem, and it ruled that the abridged version of the national anthem which is made by anyone for whatever reason shall not be played or displayed. So these are the main court rulings in regard to the Shyam Narayan Chouksey versus Union of India case. Now according to the Supreme Court, this ruling was aimed at instilling a sense of committed patriotism as well as nationalism among the citizens. But the problem was that this was criticized due to various reasons. Now what all were the criticisms against this court ruling? The first thing is in regard to the understanding that patriotism is a feeling and it can never be imposed. Instead, it has to come from within. So that's the first criticism, that is patriotism as a feeling can never be imposed. Second thing is in regard to the question of the appropriateness of playing the national anthem in cinema halls as well as theatres. Now these cinema halls as well as theatres are areas of entertainment. So critics have questioned, why not playing the national anthem in formal institutions like the education institutions? You have the parliament, the courts. Why not playing the national anthem there rather than playing it in cinema halls as well as theatres? That's a second criticism. Again, the Supreme Court ruling by directing the citizens to express their patriotism in a particular way, that is by standing, has been criticized for going against the freedom of expression that has been guaranteed by the Constitution. So that's the next criticism. Next is in regard to the lack of proper implementation mechanism that could lead to the emergence of another form of vigilantism. Now we have instances where a few people were being attacked by the vigilance, and it included even a differently abled person. So this is another criticism that has been raised. And then it has also been called as a case of judicial overreach because it has been mainly cited as an area of the legislature. So these are the main things. So this you can link it along with the liquor ban that has already been mentioned. So these are the main criticism that are against this particular court ruling. The first thing, patriotism as a feeling can never be imposed. Second thing, the appropriateness of playing the national anthem in areas of entertainment. And then it goes against the freedom of expression. Then it could lead to the emergence of vigilantism. And also it is a case of judicial overreach, or it has been criticized as a case of judicial overreach. So what are the suggestions that can be given? The first thing is in regard to the initiatives to instill patriotism. And for that we need to make use of the educational institutions which should come up with various methods that can instill the sense of patriotism among the young minds. So that's in regard to the initiatives. Second thing is there needs to be a reconsideration in regard to the court ruling. And for that, the Supreme Court has recently hinted at modifying its order by saying that it is up to the sender to take up the final call in regard to the appropriate laws as well as regulations. And it also stated that the sender should not be influenced by the interim order that was given by the Supreme Court. Now that is a welcome step, and if the sender comes up with the appropriate laws, it should be in such a way that the freedom of expression as well as patriotism of the citizens are properly balanced. So these are the things in regard to the compulsory playing of the national anthem at cinema halls.